Okay, good morning. Let's go ahead and get started. It's 10 a.m. Welcome, everybody. Thanks for coming to the unusual location, and we look forward to seeing you next month in our new hearing room. So, number one, any public comment for an item not on the agenda today? Okay, seeing or hearing none. The next item is approval of the June 2017 Commission hearing minutes. Do the commissioners have any questions or comments? And before we go on, I'm going to ask that Shiva go ahead and take roll. I hear feedback.
Commissioner Adaro.
Here.
Commissioner Hatch.
Here.
Commissioner Hayward.
Here.
Chair Remke.
Here. Okay, there. Now we're official. Okay. So with that, sorry, let's jump to the minutes again. Any questions, comments, or corrections from the commissioners? Is there a motion?
I'll move approval. Second.
Commissioner Adaro.
Yes.
Commissioner Hatch.
Yes.
Commissioner Hayward.
Yes.
Chair Remke.
Yes.
This motion passes.
Am I the only one hearing that? Yeah. Rieko, is there something on somewhere else that might be like feedback? Is it that other mic, maybe? No, we'll see. Okay, we'll just get started and see what happens. There you go.
Yeah, it sounds like.
No, it's something coming right here. All right. Anyhow, we'll move to the general item, item 3, the Rios opinion request. And Jack, I'll start with you if you just want to introduce you and your colleagues.
Good morning, Chair Remke and Commissioners. Jack Woodside, General Counsel of the Legal Division. To my right, Ryan O'Connor, Commission Counsel, Legal Division, and Trish Meyer, Assistant Chief in the Legal Division. And obviously, Executive Director Aaron Peth. I thought I would just summarize where we are today, how we got here. From 2003 to the present, the FPPC has interpreted Government Code 85305 to prohibit a state candidate from making contributions in excess of the limits set forth in Section 85301, Subdivision A, to another state candidate's recall committee. On June 12, Richard Rios from Olson, Hagel, and Fishburne requested on behalf of the Senate Democratic Caucus that the Commission make a determination of law at the June meeting that state candidates can contribute unlimited sums to another state candidate's recall committee based on the exception to contribution limits to recall committees in Section 85315. Executive Director Peth treated this request as one for a commission opinion and on June 14 denied it because the question raised is covered by commission regulations. On June 28th, Mr. Rios requested that the commission review Executive Director Peth's denial and consider granting as a request for an opinion, which is what we're here to decide today. Staff prepared a 15-page memorandum concluding that FPPC's interpretation of this issue is sound based on the plain meaning, the relevant statutes, as well as the legislative history and policies underlying Proposition 34. But we realize from the comment letters received, many others are advocating for a different conclusion, so we will attempt to answer any questions and are prepared to take direction from the Commission.
Okay, thank you. Do the commissioners have any questions for Mr. Woodside at this point, or would you like to proceed to public comment and reserve questions?
Yeah, I did.
Is that? Yes. Okay. So, Mr. Rios, we'll start with you.
Excuse me. I did say.
Oh, I'm sorry. I didn't hear you.
I just didn't have the mic close enough. I apologize. Can I call you Jack? Is that all right?
Good morning.
Would you consider that this, report was an impartial analysis, or do you think this was an advocacy piece?
This memorandum was prepared by the legal division, by staff from the legal division. It was not an advocacy piece. We researched the law and everything involved, the issues involved, and came to a determination that how the commission has interpreted this issue for the last 15 years is sound.
I didn't see any of the, specifically the Schwarzenegger cases, case, regarding his multiple ballot measures that he had, committees that he'd put together. And that opinion was published 2 years before the 2008 advice letter, the Johnson advice letter. Why was it, you suppose, I know you weren't there at the time, but why do you suppose it wasn't addressed and dismissed, or however you felt about it at the time? And it's not mentioned in your analysis.
Hi, my name is Ryan O'Connor. I'm Commission Counsel. I believe you're talking about the Citizens to Save California case. Yes, and that case dealt with a different regulation that was actually overturned, not on constitutional grounds, but on statutory grounds. And there are similarities to this issue, but it also didn't specifically deal with recall committees.
But obviously, what the court said about it would certainly apply to the situation, and yet it wasn't addressed. I can get that you might address it and say, well, we disagree and blah, 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 but it wasn't even mentioned. And so that's why I asked if this is an advocacy piece or an impartial analysis. I don't think that it is an impartial analysis in my view.
We didn't omit it because we didn't want to confront it. We looked at what had been, what prior commission pieces had looked at statutory interpretation, legislative intent, and didn't feel that the Citizens
to Save California.
Citizens to Save California necessarily changed the analysis or needed to be part of the memorandum. But
Okay, thank you.
Any further
Thank you, Chair.
questions from the commissioners? Okay, I think Mr. Rios, we're ready for you now. It has to have a green light to be live.
There we go. Is that better?
Yeah, I hear you now.
Thank you, Madam Chair, Commissioner of the Senate Democratic Caucus. My law firm is Olson, Hagel, and Fishburne. As a first matter, we just wanted to thank the Commission for hearing this issue when it wasn't ordinarily scheduled to meet on this date. So we also recognize that it wasn't ideal timing, given the fact that the Commission moved offices recently. So we would just want to express our gratitude to the Commission for agreeing to hear this issue on an expedited basis, which we think is appropriate in this context. We submitted comments, written comments, which we're happy to address any questions, Madam Chair, but I did want to raise a couple issues specifically. The first is a point that was not raised in my comments, which was just based on the strict language of 85.3. That statute does not contemplate that the contribution limits would extend to controlled committees. Am I going off?
Yeah.
Hello? Is that better? Continue?
Yeah, I'll try to do,
Hello? If I could just start by reading 85305, then I could make the point. 85305 says, a candidate for elective state office or committee controlled by that candidate, so an elective state office or committee controlled by that candidate may not make any contribution to any other candidate for elective state office in excess of the limits set forth in subdivision A. What that section does not address is that the contribution from one state candidate to the recipient state candidate, it doesn't say that other controlled committees by the recipient state candidate are subject to the limits. And this is consistent with our wait, Madam Chair?
Yeah, I'm sorry. I'm sure it's a distraction for you, and I apologize. We're just trying to get you a mic that works. So if you want to hold on for a second. I think it's those wireless mics that are causing the feedback, too. So if you just want to get real close to staff there, buddy up. Well,
Thank you. Is that better, Madam Chair?
that's better.
Great.
Is that okay with you?
That's perfect. Thank you. The point I was making, Madam Chair, is that 85305 does expressly state that a candidate or a state candidate or their controlled committee may not make any contribution to another candidate for state office in excess of the contribution limits, but it does not expressly say that limit applies to the candidate and any other controlled committees. Now, the Commission has long interpreted this section to apply to controlled committees of the recipient state candidate, and the regulations that the Commission has adopted certainly contemplate that, but the express provision of 85305 does not expressly say that the limits apply both to contributions from one state candidate to the not only the elective state, the second state candidate, but also their controlled committees. So the statute does not expressly contemplate that the contribution limits would apply to controlled committees other than the election or re-election committees that are controlled by the recipient state candidate. This interpretation is consistent with the Citizens to Save California case, which we believe expressly applies to this analysis, because in that case the court considered the extent to which Proposition 34 imposed contribution limits on candidate-controlled committees other than the election or re-election committees of the recipient state candidate. In the Schwarzenegger case, the court expressly said that the contribution limits in Proposition 34 were not to apply to committees other than the election or re-election of a state candidate. So we believe that the Citizens to Save California case is relevant to this analysis, and it should guide the Commission's decision in this case to order an opinion that says that the Political Reform Act does not impose limits on contributions from a state candidate to another state candidate's recall committee. The other thing I wanted to point out, Madam Chair and members of the Commission, is that the staff's treatment of the 85305 contribution limit as something other than a contribution limit, namely an inter-candidate transfer limit, it does not comport with the plain reading of the statute. The language in 85305 clearly says that contributions by one state candidate to another state any payment made from one state candidate to another state candidate is a contribution, and it's subject to limits. The Commission, since its 2002 memorandum that was included in the supporting documentation, has long acknowledged that an inter-candidate transfer is nothing other than a contribution. And so therefore, any limit would constitute a contribution limit that would be accepted from the contribution limits under 85315. With that, Madam Chair, we would urge the Commission to adopt an opinion which says that the Political Reform Act does not impose contribution limits on contributions from a state candidate to another state candidate's recall committee, and I'm happy to answer any questions.
Thank you. Commissioners, questions for Mr. Rios? I do have one question. Mr. Rios, do you have an understanding or interpretation whether a committee can be formed to, in your case, oppose the recall that is not a candidate-controlled committee to which the members, including the Senate Democratic Caucus, could give unlimited funds to?
That was not controlled by a state candidate?
Yes.
Yes, there's nothing in the law that prohibits a third party from establishing a ballot measure committee, essentially. And
To oppose the recall.
to oppose the recall, that's correct.
And then the Senate Democratic Caucus could give, is your understanding that they could then give unlimited funds to that committee?
They could.
Okay. All right, thank you. Any other questions?
Yeah, Mr. Rios? Do you think that's a good reason to not do this?
I don't. I don't find that argument persuasive at all. I mean, what 85-315 expressly says is that the state candidate with a controlled recall committee can accept contributions without regard to the contribution limits in 85-305. And to differentiate to make a distinction in the contribution limits as based on who's controlling the recall committee strikes us as unfair and creating a playing field that's not level.
I have one other question. One other question. Last night I was reading several new communications on this subject matter, and I read one from a law office of Max Canine. I'm not sure how to pronounce his name. It was a beautifully written piece, but he raises a whole other specter relative to our duty to try and interpret the statute in a way that would make it constitutional, and points out how the current interpretation by the Commission is in fact making it unconstitutional because of the impermissible limits on ballot measure contributions. Is there anything there you disagree with or you'd want to call to our attention?
I thought the analysis done by Mr. Cannon was exceptional on the constitutional issues, as well by the Remshow firm addressing constitutional issues which had not previously been addressed by the Commission staff. Those arguments are very persuasive. In our comments, we think you can get there without necessarily addressing the constitutional issue just based on the strict statutory interpretation, but the constitutional issues that were raised in the Remshow letter and in the Cannon letter were extremely persuasive. And if the Commission's interpretation of the statute stands, or if it stands, we think that would subject the statute to constitutional challenge.
Thank you.
I have a question. Mr. Rios, I have a question for you. So we keep talking about, and I'm going to have this question for everybody, but since you're first up, we keep talking about the legislative intent or the voter intent eventually of Proposition 34. Why do we even have to go there? Why? I mean, I understand you're responding, but do you agree that we don't even need to go there because the language of 85315, which says without regard to the contribution limits in Chapter 5, is not ambiguous?
I don't believe it's ambiguous. I think you can, and we have made the argument that you can reach a conclusion that the Commission's historical interpretation is wrong just based on that language in the statute. 85305 is in Chapter 5 of the Political Reform Act. It imposes a contribution limit, and therefore that limit should not apply to contributions to recall committees.
So that would be like our first pass at this. And if we can all agree that that language is not ambiguous, that it's clear and unambiguous, we don't even get to legislative intent, correct?
That's correct.
Okay, thank you.
Any other questions for Mr. Rios?
Oh, one other question for you. What is your response to the staff memorandum that using evident intent to understand the purpose of 85305 and 85315 and how they interact? What is, do you know what evident intent is?
I don't. I mean, the only thing that we would point to as an authority is the language in Proposition 34 and, possibly some of the intent language. But we think the statute's clear on its face that that 85-315 exempts exempts from contribution limits contributions from one state candidate to another state candidate's recall committee.
Thank you.
Any further questions for Mr. Rios? Thank you, Mr.
Thank
Rios.
you, Madam Chair.
Okay, is there any additional public comment on the request?
Good morning, Commissioners. Brian Hildreth from Bell McAndrews and Hilltack, representing the California Republican Party. I will say that one time my in-laws invited themselves to spend the night at my house, and it was the day that my wife and my 6-month-old baby moved into the house. So I get it. The family's all here. You're moving. We also appreciate the Commission's quick turnaround to have this meeting and to hear this in terms of being an advocate for government that's responsive. And so appreciate you all making time for us in what I know is a busy time for you all. First, I just want to address some of the questions that have been asked already on the constitutional issue. The state constitution says that an administrative agency is not empowered to declare a statute unenforceable or to refuse to enforce a statute on its interpretation that it's unconstitutional. So I think that's the first thing. The second thing is that in SEIU versus FPPC, which is a 1992 Ninth Circuit case, the court said the potential for corruption stems not from campaign contributions per se, but from large campaign contributions. And in terms of what the Senate Democrats are asking for today, they are essentially asking to open the door to large campaign contributions. In my letter to you all, I sort of ran through a hypothetical where if the commission does decide to overturn this statute and allow unlimited contributions, tomorrow you will likely have a number of new gubernatorial candidates who can come in and raise money and raise contributions at $29,200 per clip. And I think you can expect that some of those contributions will wind up in the 29th Senatorial District in Mr. Newman's recall committee. In terms of the Citizens to Save California, it's been a while since I've read that case, but it was not a source restriction case. And of course, the United States Supreme Court has found that source restrictions on campaign contributions are permissible. In federal law, there is a source restriction on corporate campaign contributions to candidates seeking office. It's different than what is in the other parts of Chapter 5, which are receipt restrictions. In other words, what committees can receive. So 85305 is written differently, it's drafted differently than the other campaign contribution limitations. And I think if you run back to the legislative intent, which Mr. Woodside has put into his memo, it's clear the voters were voting on an issue, or one of the issues that they were voting on, were establishing limits on transfers between candidates. And the argument in favor of Proposition 34, as Mr. Woodside points out, one of the purposes of it was to prevent candidates flush with cash from swooping in at the last minute to try affect the outcomes of election campaigns. So certainly the regulation that accompanies 85305 does contemplate limits that maybe the statute doesn't directly contemplate, but certainly the regulations that are in place presently do contemplate that this is also a limitation on committees controlled by candidates. Those are the basic points that I wanted to make. In terms of Mr. Burton's letter, of course, material showing the motive or understanding of an individual legislator, courts don't consider that as true evidence of legislative intent, so that letter probably should be disregarded. Many of the other letters address the constitutional issues, which I've addressed here. Thank you.
Okay, thank you. Questions? Commissioner Hatch?
You kind of carefully carved what you said relevant to the source restrictions. you specifically limited that to source contributions to candidates. But in fact, this is a ballot measure, a special kind of ballot measure, coupled with elections for other people that are not affected by the target member. I think if you were to broaden your remarks, you'd had to reverse yourself, wouldn't you say?
Well, no, this is not just a ballot measure committee. It's a candidate-controlled ballot measure committee. So there is an additional restriction that you are not then sort of considering in the form of that question. So there is a distinction between a ballot measure committee and a candidate-controlled ballot measure committee.
But the point here is that giving contributions to that committee can only be used for that purpose. They can't be recontributed to any other purpose, and it's only for defending in a ballot measure. And then after that, all those funds have to be then, either returned or disposed of in a safe manner. And
Political, legislative, or governmental purpose is the sort of the rule of thumb for political dollars. So I guess as long as they comport
so how do you
with that.
find the potential for corruption there?
Well, the Supreme Court has made a number of findings, or at least the federal courts have, and one of their arguments or reasons for permitting limits on transfers between candidates is to limit the potential for corruption. And I read that right out of the SEIU case versus FPPC. So however you want to interpret that, that's...
Those were for supporting candidate elections. We're not talking about that. We're talking about defending a ballot measure.
Well, by a candidate and with his or her candidate-controlled committee. So, and of course, this is the rub. This is where the distinction is. This is what we're here to decide. My argument is that 85305 does limit those contributions or transfers between candidates if one of the candidates is running a candidate-controlled ballot measure committee.
You're not reaching me, but thank you.
You're welcome.
Any further questions? Commissioner Odero?
Thank you. This is the flip-flop of the argument that your firm made in 2008, right?
Right. Well,
So what has happened between 2008 and today?
The letter from 2008 was due in large part to inconsistent advice that we had received from the Commission's legal division. Our associate attorney at that time had a telephone conversation with the technical assistance line, which at that time, it's evolved a little bit, but at that time there was much more back and forth, engage on substantive issues, and so we initially received advice through an email that said no limits, and then we received a follow-up email that said, well, legal is now telling me that there are limits, that the limits are in effect. And so we wrote the letter basically seeking clarification, and we were advised to write the letter. The legal division said, please write in so we can respond to this and sort of publicize what our advice is on this issue.
But your letter isn't just a letter asking a question. Your letter is an advocate piece, right? It's an advocacy piece saying we believe there should be no limits.
We tried to provide justification why we thought there would not be any limits.
So what has changed since then?
Well, I think the number one, the Commission's advice, which we readily accepted, did not challenge the advice. We followed it. Our client at that time followed it.
And so now you agree with the advice, even though in 2008 you didn't?
Well, I think the interpretation is persuasive. So that's in terms of the interpretation of the advice letter, which I have sort of parroted back in my letter to you, which is outlined in Mr. Woodside's memorandum. So yes, I mean certainly, persuasion is evident here in terms of the way that the legal division interpreted that rule.
So let me just make sure we have a clear record. In 2008, your firm, on behalf of the Republicans, advocated for no limits on this very same question. You called by phone, you got an answer, then there was a letter, you got an answer by email, then there was a letter that basically said, oh, never mind, we've rethought this, there are limits, and your firm then wholeheartedly agreed, such that 9 years later you're saying, that was absolutely right.
Well, we accepted the advice at the time, and we accept it now. Yeah.
That's not my question, and I don't mean to be rude, but accepting advice is a whole different thing from agreeing. So I'm going to ask you, do you agree with this conclusion?
Well, I think the analysis is sound. That's what I'll say. Do I agree with it? Sometimes I'm in court arguing two issues, one time on one side on the other side. So, but when the analysis is sound and when the law is sound, which I think it is here, then, so in terms of do I agree with the analysis and the conclusion, yes, I do.
Okay, then.
Any further questions,
Yeah,
Commissioner?
good morning. I think it's useful that we've been reminded of our limited authority to engage in constitutional, not just analysis, but decisions here as members of the commission. But I also think, first of all, I wonder if that prohibition is in fact constitutional. And I'll just set that out there because I took an oath to uphold the Constitution of the United States as well as the state of California, and there seems to be a little bit of a rub there. I guess I'm still baffled at how 85305 is not, in fact, a limit in Chapter 5, because it would seem to me that it is, and the plain language 85315 says those limits don't apply.
And my response is, and it has been, that the contribution limits are limits on what somebody can receive, and I think 85305 is a limit on what somebody can do. So I think 85305 is a source restriction.
I understand that, and I understand that the staff memo also contains a similar analysis. I just don't see support for that bifurcation in the Act. And it is a bifurcation that, frankly, new to me, and I have been doing this more than just a week or two. And so I think that could be a solution to a problem, but not necessarily an analysis that has been carried through much of the history of our work on the Act here. Where is that bifurcation in the statute or in a case that interprets the statute?
The bifurcation between
a contribution is only a thing that you do or a thing that you get or I mean, you tell me, because it's not my distinction, and it's not a distinction that I found in the Political Reform Act.
Well, and Mr. Woodside can maybe add some more color to this, but across the political contribution campaign finance spectrum, there are similar bifurcations in terms of what individuals can make and entities can make in various circumstances. So my reading of 85305, and just to repeat myself, I'll say 85305 to me is a limitation on what can be pushed out. The other campaign contribution limits are what can be received.
I'm trying to think of another situation there, though, where the recipient is blameless if an unlawful contribution is made. Because that seems to me to be where this argument goes, is that the recipient can take whatever the recipient wants. It can take, snowflakes from the sky. It can take money from, Charlie Chan. But it's the donor that has the limit here. I understand most limits to be two-sided, where there's a violation by the recipient for taking a legal contribution and a violation by the donor for making it. But this argument seems to come up with a different kind of contribution limit, and I'm puzzled by that.
Right, and I guess I think you're right. The Political Reform Act says, no person shall make and no person shall receive. for contribution limitations. This says no person shall make. So I don't know what the result would be if Mr. Newman were to receive money, or in terms of what Mr. Newman's responsibility would be if he were to receive $10,000 from a legislative candidate and accepted that money. So I don't know. It would be something for enforcement. But what I do see in that statute is a limitation on what candidates can make to other state candidates. So yeah, I don't know what the result would be.
All right,
And I
thank
don't know what the liability would be.
Thank you.
Madam Chair, I have another question.
Commissioner O'Darrow?
Thank you. So if it's not a limitation on what somebody can, you're making a distinction between the use, right? A limitation on use. Is that what you're saying?
Right, source restriction.
Okay. So I just wanted to make sure we were talking about the same thing. Doesn't SEIU say that limitations on use are not constitutional?
Well, it does say that now in terms of the dicta or the part of the conclusion of SEIU was acknowledging that that limiting large campaign contributions, large transfers, looked to be like it would be something that was acceptable.
No, I'm not going there. You're going to the inter-candidate transfer part of SEIU. I understand that. I'm trying to take you back to the language of SEIU where the court made a distinction between intra and inter-candidate transfers. And I know we're not talking about intra-candidate transfers, but the fact is that SEIU, the court in SEIU said, one is a use limitation, right? And the use limitation is not constitutional, right? But that's because they analyze the intra-candidate transfer within that paradigm, the paradigm of strict scrutiny, right? And so all I'm saying is, if we use SEIU for the proposition that use limitations have to be analyzed on a strict scrutiny standard, right? You have to have a narrowly tailored means to serve a compelling state interest. Okay, so if that's how we analyze use limitations, let's do that here, since you're saying that this is a use, 85305 is a use limitation.
Sure.
So what's the compelling state interest to limit an inter-candidate transfer into a recall committee?
According to SEIU, it is the potential for corruption.
No, but that was, no, SEIU, you can't go to SEIU because the potential for corruption had to do with the fact that the money was going to influence a candidate. A recall committee, that's not where the money is going. This is what Commissioner Hatch was talking about. So what's the compelling set? Forget SEIU other than for the paradigm that we're going to use. What's the compelling state interest for limiting inter-candidate transfers to a recall committee?
It's not just a recall committee. It is a candidate-controlled recall committee.
How is that different?
Well, how is it different?
In this case?
One is controlled by a candidate. And according to SEIU, that's where the potential for corruption comes in.
No, that is not. I respectfully disagree with your interpretation of SEIU. SEIU was not talking about a recall committee. SEIU was talking about a candidate election committee. And I understand that that's where the issue of corruption went. I get that analysis. But I think that the ship has sailed on what is the difference between a recall committee and a candidate election committee. The FPPC has, for as long as there was stuff on the website that I could find, has been saying a recall committee is different than a candidate election committee. Cases have said this. That ship has sailed.
Well, I think the distinction here is that a candidates committee is more closely associated with a candidates controlled recall committee versus a garden variety recall committee. So that's the distinction. So here we have and that's where the potential for corruption comes back in, because it's a committee that's controlled by a candidate, be it the re-election campaign committee, be it the candidate controlled recall committee. that is where the link is made between the potential for corruption and a committee that's controlled by a candidate. Whether it's recall, re-election, new election, the fact that the candidate is controlling that committee, that's where the potential for corruption comes in.
And where is the authority for that, other than some people who want it to be that? I haven't read anything that makes that kind of a distinction.
Well, where is the authority for treating a candidate-controlled committee, a candidate-controlled recall committee, same as a candidate-controlled, like, re-election committee? Well, the fact that they're both candidate-controlled. I think
but who says that? I know that you want it to be that way. I get it. It helps your argument. Who says? Where's the authority? Where in the Political Reform Act? Where in case law?
Well, I think that this is an issue of somewhat first impression. I'm not sure it's been stated explicitly like the way you maybe want to see it. So everybody's here sort of trying to chain together.
Right, but I understand. I understand that's where we're going. I just want to make sure that we're all very clear that we're not accepting that premise. Some people are not going to accept that premise, right? That a candidate-controlled recall committee is more like a candidate election committee than a recall committee. Mm-hmm. That is just something that's being thrown out there. And I understand that that's the debate, but that is not a given. There is no authority for that. You would agree?
Specific authority to that? No. But what there is authority for is the potential for corruption arises when it's a committee that's controlled by a candidate. And when I say that, like a candidate re-election committee.
So I would disagree with you on that as well. I think the authority is there is a potential for corruption in a candidate election committee, whether it's candidate controlled or not candidate controlled. There is no authority that says that there's a potential for corruption. No court has found that there's a potential for corruption as the compelling state interest that we want to protect against in a candidate-controlled recall committee.
Except both, in terms of the candidate re-election committee and a candidate-controlled recall committee, both contemplate that officer's ability to continue in his or her office. That's why it's closer. That's why a candidate-controlled recall committee is more closely aligned with a candidate re-election committee than it is a garden variety ballot measure or recall committee.
But the law does make a distinction. I mean, we do have authority for the distinction between a committee established to support or oppose a recall versus the committee for the election of the replacement candidate, right?
Correct.
Okay.
Right.
So there is that distinction has been made. I just don't know that the distinction you want to have been made or you're advocating exists. I don't think that distinction has been made. So that's all. We will have to disagree.
Sure.
Any other questions from the commissioners? I would just ask the same question I asked Mr. Rios. And again, not that I'm just trying to understand the full scope of the issue and the flow of money here. And so would you agree with Mr. Rios that a committee can be formed to oppose the recall that is not candidate controlled, to which the Senate Democratic Caucus members can give unlimited funds?
That's correct. And the reason why there would be no limitation there is because now the potential for corruption is removed. If it's you and I that are establishing this recall committee, be it pro or against, we're not running for that office. We're not potential replacement candidates. It's not our office that's at stake. So in that way, we're not in the focus or under the microscope of corruption, whereas somebody who controls a recall committee, a candidate that controls it, it's their office that's at stake. And so they're the ones that are under the gun for potential for corruption. Long way of saying, yes, the candidates can make unlimited contributions to non-candidate controlled recall committees.
Okay. All right. Any further questions from the commissioners? All right. Thank you. Any additional public comment? Okay. Commissioners?
I've got another question of Mr. Woodside.
Commissioner Hatch?
Thank you. As expressed in the document prepared here, the FPPC's interpretation is that 85305 is a standalone limit on inter-candidate transfers, and it's a term that was wiped out of the Act in Prop 34. It was all of the references everywhere in the Act were repealed by Prop 34. In a sort of a key issue in in order to justify what the Commission's position has been in the past, has been to engage in sort of a legal fiction. On its plain face, it refers to itself as a contribution limit. And yet, grabbing some piece out of the analyst's analysis of Prop 34, you say it's not really a contribution limit, it's this transfer limit. Well, transfers, that's a term that's archaic now. It doesn't apply. It's no longer defined. It's not used. It's specifically repealed. And when you're trying to make sure your interpretation fits, obviously other writers said that you should be looking at constitutionality. I just wanted to look at some of the other maybe unintended consequences of this. And so when all of these provisions of the PRA are no longer here that discuss or regulate intercandidate transfers, does that mean then that if one candidate were to give funds to another candidate, in my view, in violation of that provision in the code, would they then, because it's not really a limit on contributions, and so therefore it's not a contribution, it's a transfer, does that mean that neither the receiver or the giver have to report it on their statements? Because, in fact, it's not a contribution, so therefore it's not subject to PRA requirements for filing reports of the contributions you gave or you've received. It's kind of silly, isn't it? You can't harmonize that. I'm not saying that people go out and do it, but I'm saying it doesn't fit. It's kind of like the OJ trial. If it doesn't fit, acquit. It just doesn't work.
It's very timely.
Can you figure a way around that and tell me why I got this wrong?
I just want to make sure I'm understanding you. We're looking at how we're characterizing the money going from the donor to the receiver.
The very foundation of the argument, and this repeated over and over, is the same thing. It's not really a contribution limit. It's, in fact, a transfer limitation.
Yeah, I think the point's the same. It's money going from the donor, the state candidate, to another state candidate. Now, we can call it a contribution.
But the point is, on its face, it says that it's a limit on contributions. You say it's not really a limit on, it's not really one that can be considered as waived because it, in fact, is not a campaign limitation, contribution limitations. It's, in fact, this archaic term, it's an intercandidate transfer. So if it really isn't an intercandidate transfer, as is argued in your report, then, in fact, all these other provisions that limit contributions would no longer apply to these transactions. So I could give money, if I were a candidate with my committee, I could give money to this other candidate over here, and he wouldn't have to report it, and I wouldn't have to report it. We'd have a hell of a time even trying to enforce it because nobody's going to tell on themselves.
Yeah, I think
It's nonsensical. And yet that's the very foundation of our existing advice letter.
It's a use restriction. Listen, 85305 references a statute that sets forth the general contribution limits.
Doesn't matter. Each
Well,
of them
it does.
are contribution limits.
It does because 85305 isn't setting that limit. It's pointing to another statute that actually sets that limit. No other statute points to 85305 to say, hey, there's the limit. The limit on whatever you want to put the limit on, look to 85305.
It took just a portion of 85301 that it found applicable, and by making a reference to it, it made sure that that limit continues to grow with the cost of living.
Right.
Whereas if it had explicitly placed the same words in that section, they would not, without having to go back and amend the COLA section, it would not be increased year after year. And that was the reason, as I discern, that it was cross-referenced.
Right.
And it was a perfectly clear cross-reference. And it had a purpose. Okay? So why is it we're going to call it something else so we can avoid calling this a contribution limit subject to waiver, and not then say that it's okay to not report it?
Well, I think the point we are trying to make is that 85305 serves a purpose that's different than just this. These contributions were banned under Prop 73 and Prop 208, and 85305 was created specifically to control the use of these contributions by state candidates to other state candidates. So it's different. It's yes, it does have a contribution limit as part of its as part of the statute, but it doesn't set that limit. It looks to another statute that sets that limit. And that's why we've been arguing the other statute that sets the limit. Those are the general contribution limitations of Chapter 5.
And these are special contribution limits that only apply to a certain class of givers.
Well, they apply to the state candidates, but there's also another purpose for 85305 that's different from those general contribution limits.
But is it or is it not a campaign contribution limit? You say no, it's not in your paper.
Well,
and in fact, in the advice letter.
We believe it serves as a use restriction on campaign funds between.
A bit of a dodge, don't you think?
Well, I mean, I think we're just trying to point out that 85305 has this special purpose that can't be overlooked, and we have to ask, well, what are those purposes? And one of them was to control money flow between state candidates so that they wouldn't influence the outcomes of close elections.
Well, I respectfully disagree. Thank you. Chair.
Commissioner O'Darrell?
Thank you. Okay. If 85305 is not a contribution limit, how do you reconcile that with the commission opinion of November 1988, which says the specific contribution limitations in Proposition 68, that's the opinion that was trying to
Can you say
decide-
the name of it just so we can all
of course.
know what you're
I-
referring
sorry.
to?
Opinion requested by Charles Bell. And it was an opinion that the question was, what if 68 survives in light of the vote of having voted in both 68 and 73, because there was some overlap between 68 and 73. So the question was, what if 68 survives? Because 68 had gotten less votes than 73. In the course of answering that question, one of the things that the commission said that there was no dispute about between 68 and 73 were contribution limits. And it references sections 85300 through 85305 as the contribution limit scheme. So for a long time, the commission has been saying 85305 is part of the contribution limit scheme. How do we get around that?
I think that there is obviously a part of 85305 that does involve contribution limitation. It references a statute that's
Okay.
obviously,
So,
but we look too at the ballot pamphlet and how the ledge analysts characterize 85301 and 302 as the contribution limitations of Chapter 5.
so what's 85303? Isn't 85303 also a contribution limitation?
Yeah, I would say so, yeah.
So the fact that ledge analysts didn't list 85304 as a contribution limitation doesn't mean that it's not.
It was just another point that we were looking at to try and differentiate the two.
Okay. How do we get around SEIU, which says, sorry, I've got the wrong glasses on. In contrast to intra-candidate transfers, inter-candidate transfers, which is 85305, operates as a contribution limitation. How do we get around that?
I guess I don't understand your question. How do we get around?
How do we get to sit here and say 85305 is not a contribution limitation when a court has said 85305 is a contribution limitation?
Well, I don't know how we get around it. All I can tell you is we looked at the legislative intent, looked at the ballot pamphlet, looked at the different interplay between these statutes, and came to the conclusion that that what had been said in the Johnson letter was sound. So there may be other cases that we didn't reference that use those terms, but what we found as support seemed logical to us.
So, fair enough. I looked at Prop 34. I also looked at SB 1223. I think it was SB 1223, which is what put Prop 34
I believe
on
it's
the ballot.
1123.
I'll find it. Hold on. It's what put Prop 34 on, or tried to put Prop 34 on the ballot.
You wrote the measure and
Yeah.
then ordered it to
Hold
be
on.
put on the ballot.
Thank you. And as I read, SB, it is 1223.
Yeah.
I read it to say, in fact, I'll just quote it. This bill would subject candidate-to-candidate transfers to contributions outlined above, which were the contribution limits 85301 to 85303, but those are specifically referencing candidate elections. And then I read that to committees established by a state officer to oppose a recall measure and recall election, no limits on contributions. So that's 1223, which addresses a discussion that we had earlier, which was trying to make the distinction that there's a world of difference between a recall committee and a and a candidate controlled state recall committee. And I read this to specifically say a state officer can establish a committee to oppose a recall to which there would be no contribution limits. how do we get around that?
I'm not sure we all have the same documents in front of us. Is that the problem? You guys are looking for what she's referring to?
Yeah, I'm sorry, I don't.
Do you want to see mine?
What's that?
Do you want to see mine?
Can I make a suggestion? It feels like, can I
If
just?
I could, this is a
No,
very important point.
I know. Can I make a suggestion though
No,
first?
I have the floor right now. Hold on.
Okay. Go continue, please, with your questioning.
So I'm happy to share what I have. It's just the SB 1223, the Senate bill analysis. I'm happy to pass. Okay, I'll show you the page.
Okay. And what was the question?
How do we get around that?
State what you're reading so I understand what we're trying to get around.
Okay, it says, to a committee established by a state officer to oppose a recall measure and recall election, no limits on contributions. And I think essentially what that's saying is, yeah, when a state officer state candidate sets up a recall committee, there are no limits on the contributions.
Isn't that,
And we're,
am I misunderstanding? I'm sorry, but am I misunderstanding? Isn't that what you're saying there are limits on?
well, we're saying that that there are no limits on the acceptance of contributions. And this is the point we were trying to make, that 85305 considers the making of a contribution to another state candidate, which in our analysis and our opinion is different than accepting contributions into a committee set up for a recall.
Okay, so then now we're back to the question that I posed earlier, which is you're saying 85305 is a use limitation.
Right.
Okay, so let's go there. What is the compelling state interest that justifies limiting contributions, these intra-candidate transfers, to a recall?
I understand, and I think Brian Hildreth was right. This is kind of a first impression. There are no courts or no cases that we're aware of that discuss this.
Fair enough, but what is
But
your
we
thought?
think, you know, there's this technical argument that recall committees fall into the ballot measure scheme, but practically speaking, they are candidate controlled, and they are dealing with candidates that are running to maintain their office. So that's how we've viewed these, kind of this intertwined ballot measure and election committee, you know, rolled up into one.
But that is, on that point, you sort of mix those two. They're treated differently under the law. The committee that the candidate, the target member forms cannot be used to run for election, even in the recall election portion. In other words, if the initial question is, yes, he's recalled, unless he's termed out, he can also put his name on the ballot. He cannot use funds under the terms of that section to reelect himself under the recall. He can only use it to defend on the primary question, shall he be recalled?
I'm sorry, I don't understand the question. Is the question if the recall was successful and he wanted to turn around and run in the follow-up race?
It's simultaneous. All the candidates have to file ahead of time. So it's like question A and question B. Do you recall? Who do you vote for?
So you're saying he'd put his name on for the
And
separately for the.
Mr. Woodside was alluding to this money in this committee being used for both purposes, and it cannot. By law, it can only be used for the defense on the primary question. I'm just holding you to the bar here.
Commissioner Hayward?
Yes, now that, and I am humbled by Mr. Hildreth's admonition that we shouldn't get involved in too much constitutional analysis here as commissioners. And I guess I think the staff did a very good job of justifying the interpretation that we've been working under. I do wish that you had done something analytically with the Citizens to Save California case, because humbled as I am as a constitutional advocate or interpreter, I feel like we need to be following this case. And it seems to be on point. Here we have a case where the FPPC had an interpretation that 85305 limited contributions to candidate-controlled ballot measure committees, admittedly not recall, but if we're treating recall committees like ballot measures, which I think is also interpretively what we need to do, here's what the court said. It appears the FPPC recognized that Citizens Against Rent Control, which is the ballot measure, no limit thing, right, precludes limits on contributions to ballot measure committees and attempts to evade this prohibition by the legal fiction that contributions to a candidate's ballot measure committee are made to the candidate and thus may be subject to the candidate contribution limits. But the FPPC does not treat these contributions consistently as being made to the candidate. For example, we don't impose the one bank account rule. We don't aggregate the limits between a candidate-controlled committee and the candidate-controlled ballot measure committee. There's lots of things we don't do to candidate-controlled ballot measure committees because they're ballot measure committees. And the same would apply to a recall committee. I just don't see how you get, even if you weren't going to just stick with the plain reading of the statute, which I honestly think is all you need to do here, it seems to me that we've got a court telling us what our answer needs to be here, and it's not what you're telling us. And, you know, again, I think the other side on this point has done a very good job of marshaling all the resources they could bring to bear to come up with the other conclusion, but I think the other conclusion's wrong.
Okay, so I'm going to take the floor for a minute, and my suggestion earlier was going to be that since it seems that there may be some consensus on the direction that the commissioners like to go, rather than continue through this exercise of the law, is to state your position with the grounds to support it so that the staff has some direction. Because if there is a majority position as to the direction, that could get us there faster. So I would encourage the commissioners to state where they, even if it is tentative at this point, where they see their position going. For example, if you think that there should be an opinion that reverses the commission's interpretation, state so, and the grounds, so that we're giving staff direction as to where to go. And then if there is a majority, which I'm sensing there is, they could even have a tentative draft opinion for the next hearing. Right. If there's enough direction and agreement as to why that opinion should be issued. So that's where I think the most useful time would be now. Otherwise, I'm afraid we are going to end up having at least 2 more hearings to get to an opinion point, if that is what the majority is, which sounds like it is. So I think it would be more helpful to state, again, where you would like to see us go and the grounds that support that, so that we can get a consensus.
When you're finished with that, I'd like to make a motion.
Okay. You don't want to state the grounds or?
When you finish with that, not what you just said, but conducting that poll, the poll.
Well, again, it's my suggestion on how we can build or is to see if there's a consensus. I don't think it would be sufficient or lead to the road where maybe some want to be if we just say issue an opinion, because clearly staff needs direction on the grounds in which to issue an opinion.
Yeah, and
Well-
I have a motion on that, yes.
Okay, well, with my fellow commissioners' indulgence, I'll start, which is, I think, by repeating what I just said, that I think a plain reading of Chapter 5 is that 85315 means what it says.
Can I ask, are you starting with we should issue an opinion?
Yes, we should issue an opinion. Oh. It's like taking roll. I can say it at any time.
Okay, I know.
Okay. 85315 means what it says. 85305 is a contribution limit. I don't know where intercandidate transfer came from. It's an awesome phrase. I don't know where it is in the Act, though. And that if we need more than just the plain reading of the statute, we follow the interpretation of the California Court of Appeals in Citizens to Save California, 145 Cal App 4th, 736. And that does it for me.
Right. Any other commissioners want to?
Simple. Ditto. I wholeheartedly agree. 85305 is a contribution limit that falls within the contribution limit scheme that is contemplated by 85315, just on its plain meaning, on a plain reading. We don't need to go to legislative intent. But if we have to go to legislative intent, I don't believe that Prop 34 informed the voters that 85305 is not the contribution limit contemplated by 85315. I have no idea what is meant by evident intent. I think it's something less than legislative intent, but I've never heard it. But to the extent that it's, if I'm right, that it's less than legislative intent, then I think it gets even less of value. I think that the argument that it is so because this is how we've been doing it really has no validity. I would say antiquity brings no information to the validity of the rule. And at the end of the day, I don't see how we can replace plain, unambiguous language of without regard to the contribution limits of Chapter 5 with language that is supported by less than legislative intent to say without regard to the contribution limits of only 85301 and 85302. And maybe, I guess you would have wanted to add 85303. And so for those reasons, I think that we should issue a commission opinion as stated by Commissioner Hayward.
So you want to, you said a lot more after that, but really the grounds in which they would do it are the earlier, as you said, as Commissioner Hayward stated.
No, I meant, sorry for not being clear. The commission opinion would conclude what Commissioner Hayward was saying for all the grounds she stated, as well as for mine.
Commissioner Hatch?
Well, in my view, clearly the drafters of Prop 34 intended to change the narrative when they chose to characterize the giving and receiving campaign funds from one legislator to another as contributions and no longer as transfers. Hopefully, here today, we're going to correct these past injustices. And based on this that were articulated in your memorandum, although it's beyond the power of this commission to repair any damage that was occurred in the past because of this longstanding advice letter. I think it's now time for us to do the right thing and reverse this longstanding Johnson advice letter. And I would have a motion that's very specific as to how that would be, if I can read it to you.
Well, maybe I'll make my comments first, and then we can hear a motion.
That'd be fine.
Is that fine?
That's fine.
Okay. Well, today I'm going to be voting not to issue an opinion, and I also have several reasons. Most importantly, I believe that the longstanding commission interpretation is correct. I believe that the commission followed an impartial and rational decision-making process to reach that conclusion, and it was not just in the advice letter, but it's also set forth in regulation and a recall fact sheet approved by the commission. Now, if any of the interested parties that are appearing before the commission now disagreed with that interpretation, they had a variety of avenues to address it over the past 15 years. Obviously, that includes a legal challenge, a statutory amendment for clarification, or even an initiative. I also think that it is important, and the agency has a duty of consistency, and that we should adhere to our own informed judgment. Without a change in the law, a court decision, or even a strong factual showing that there were unintended consequences to our interpretation, I do not believe there is any sound basis to reverse our position. None of the arguments made today in the public comment letters are new. They were and have been available for the last 15 years through at least 2 recall elections. In fact, none of the players are new. The only changes have been the makeup of the commission and the current pending recall. Under those circumstances, I believe any decision to rescind our prior interpretation at this time could have negative consequences. And just to point out a few which I could see is that such a reversal could be considered political, potentially impacting the public's perception of the integrity of the commission. I also believe it could set an undesirable precedent that with each change in the makeup of the commission, settled law, rules, and policy are subject to change, which I think would bring undesirable uncertainty. And of course, a reversal in this politically charged environment could subject us to what I think is unavoidable litigation against us. So in short, I think this is the wrong time and the wrong venue for the commission to reverse its legal interpretation. So that's my position. I think, Commissioner Hatch, you wanted to make a motion?
Yes, thank you, Madam Chair. I move, and I can supply this language, I move that pursuant to Regulation 18321, the Commission hereby grants Commission opinion requests sought by Mr. Rios, and further move the Chief Counsel be instructed. I move that pursuant to Regulation 18321, the Commission hereby grants the Commission opinion requests sought by Mr. Rios, and I further move that Chief Counsel be instructed to cause a draft Commission opinion to be prepared and properly noticed for consideration by the Commission at its regular August meeting, which draft opinion analysis and conclusion shall be in accord with the analysis and conclusion of Legislative Council Opinion Number 1716447, which is the one that's in the package that we have. Do you have a second?
I'll second.
Can I make a friendly amendment? Friendly? It's just, I'm not sure I heard the beginning part of the motion clearly, but just so that we're following due process, we're moving to, the motion is to grant the request for an opinion. That would be a tentative opinion that would be presented, because there still is, once we grant the request for an opinion,
I said draft opinion.
Okay, so because there'll still be an opportunity for briefing and hearing at the next thing. Okay, I just wanted to make sure we were clear on that. Sorry to interrupt. Go ahead. Is there a second on the motion?
Second.
Commissioner Adaro,
Yes.
Commissioner Hatch,
Yes.
Commissioner Hayward?
Yes.
Chair Remke?
No.
This motion passes.
Okay. So, as to my point, I just wanted to be clear that the regulation and the Administrative Procedure Act do require that what we've done is said that there will be, the Commission has agreed to issue an opinion. The parties still have any interested party still has an opportunity to file a brief, and then we can hear further oral argument if necessary at the August hearing. And just as far as the dates go, the regulation says that a staff memo at least 2 weeks and then briefs at least 5 days. But since 2 weeks is next week, and all those dates are waived or we can waive, so I would propose that the staff memo and the proposed draft opinion be posted the normal 10 days to just give staff sufficient time. So it would be 10 days before the hearing.
But wait, doesn't that give less time to somebody who's going to oppose staff's memo?
Well, they still would have, we could change, any briefs are supposed to be due 5 days before the hearing. We could reduce that time as well to address that, to kind of make it a little bit more even. I don't know if it's...
Right, because the idea is to give somebody who is going to have a position opposing staff's memo 15 days.
No, 5.
No, 15. If staff's is due 20 days before.
No, 2 weeks.
14.
Oh, sorry,
2
14.
weeks.
14. Okay, 14 days before our next meeting, and the memo, any response is due 5 days. That means that they get 11 days to respond. Right?
Right.
Am I doing the math right?
No, 9.
9, excuse me, yes.
Why?
14 and 5, so that's 9.
Yeah, 9. Sorry. Yeah, I'm doing the math wrong. Okay. Don't tell my kids. So we have to make sure that under the 20 and 5 rule, right, they would get 15 days.
Any briefs are due 5 days before the hearing. Right now,
So we could move that to
Would be in
1 day.
response to the staff memo being due 20 days.
no, 14 days.
No,
No, isn't it 20 days before?
it's 14 days.
Calendar days,
Sorry. Okay. That's
So
where
why
I'm
don't we
getting it
just
wrong.
have briefs
Okay,
can
got
be
it.
submitted up
We
to a
do
day
10
before.
and then 1, that's
Okay,
9.
yeah.
So.
Yeah. I just want to make sure that anybody who has an opposition has
Right.
ample opportunity so that later it can't be said that we have deprived anybody of an opportunity for public comment.
Okay, so the staff memo and the proposed draft opinion will be posted the normal 10 days before the hearing, and any opposition briefs or any briefs, even in support, can be submitted up to a day before the hearing. Okay, is there anything else?
Can I have my sheet back?
Is that sufficient?
By
or do we have to
12:23.
vote on that?
That would be the motion. I'll just
I second.
okay.
You have to take a vote.
Commissioner Adaro?
Yes.
Commissioner Hatch?
Yes.
Commissioner Hayward?
Yes.
Chair Remke?
Yes.
This motion passes.
Okay, any other comments? All right, I move to adjourn.
Second.
Commissioner Adaro?
Yes.
Commissioner Hatch?
Yes.
Commissioner Hayward?
Yes.
Chair Remke?
Yes.
This motion passes.
Thank you.